There is one more argument set for this morning, and that is Theresa Cook versus David Cook, 18CA0042. Counsel is present for both parties. So each of you will have 15 minutes to argue your case. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you're going to reserve time, and I'll keep track of that for you. The court has read the briefs and are prepared to proceed with argument. If there's reference to any children in the case, please use just initials and not names. Let me reset the clocks here. Okay, appellant, would you like to reserve any time?
Yes, Your Honor. I'll reserve 3 minutes.
3 minutes. All right, you may proceed. Thank you.
Thank you, Your Honor. May it please the court, my name is Adam J. Thurman from the firm of Rosenthal Thurman. I'm here on behalf of the appellant, David Cook. Just by way of quick background, Your Honor, the parties were divorced in February of 2014. There were 2 separate support orders in the divorce decree. Spousal and child, each being $800 per month. In both sections dealing with child and spousal respectively, there was very specific language with relation to the modification of those orders, and ultimately is the basis of this appeal. The language in particular, Your Honors, indicates that the parties stipulated and agreed that any modification of child support or spousal support as set forth herein during the period of time that spousal support is due and owing as outlined above shall necessitate a modification of spousal support to result in the same net after-tax effect as the combined child and spousal support orders as set forth herein. In May of 2016, Your Honors, the trial court set the matter of child support for review hearing due to the parties' eldest child, C being set to emancipate that summer. Just by way of knowledge, Your Honors, this is a matter of course in the Medina County Domestic Relations Court when a child emancipates. While those proceedings were pending, the appellee filed a motion to modify spousal support in September of 2016. Both of those matters were heard together, were submitted on stipulations in December of 2016. The trial court issued its judgment entry in May of 2018, increasing spousal support substantially and actually exponentially. Your Honors, the entirety of the trial court proceedings that resulted in this appeal turns on the interpretation of that paragraph that I just presented a few moments ago. We firmly believe that there is only one interpretation of that paragraph, and that paragraph, which appears again both in the spousal and child support sections of the parties' judgment entry of divorce, is in fact unambiguous. Its plain meaning requires that if either of the $800 per month support payments were to be modified, then the other payment would also have to be modified to necessitate a result of the same after-tax effect of the $1,600 combined number as specified in the divorce decree. The trial court, using grammar principles, found that the word same was an adverb only modifying the net after-tax effect and not modifying the phrase combined child support and spousal support orders as specified herein. As this court is aware, the placement of a comma can have a profound, if not definitive, influence in how a paragraph in a contract or agreement is construed or interpreted. In the case called State v. Hart, which is cited in appellant's brief, there are a couple of examples of punctuation placement that results in a turn on interpretation of a particular clause. One of my favorites is the Graham example. Is it, are you going to eat grandma or are you going to eat grandma? Both of those clauses, even though the exact same words, have different meanings based on the placement of the comma. The comma in our clause, the one that appears in the spousal and child support sections of the judgment entry of divorce, makes the modifier, the word same, apply to the entirety of the following clause, not just half of the clause. And additionally, Your Honors, I think even focusing our attention away from the grammar argument, we have additional problems. The trial court seems to ignore the phrase "as specified herein." Under the same logic and principle of the trial court's decision indicating why wouldn't we go as far as to specify that the number $800 on each side of the support payments could not be modified, which creates other problems. Why would the phrase "as specified herein" be inserted into the clause if that didn't or wasn't the intent to reference the $800 a month spousal support payment and the $800 a month child support payment? From a mathematical standpoint, Your Honors, even the trial court's example of what the party's intent regarding modification is in clear error. On page 3 of the judgment entry, which is being appealed, the trial court maintains that appellant's position is that if child support were modified to a reduced $665 per month from the $800, the spousal support obligation would have to be increased to $935 per month to get an even $1,600. However, what the trial court fails to consider in that example is the net after-tax effect. The party's spousal support order issued in 2014 has a tax effect, unlike the support orders now being issued. In 2014, the spousal support order is deductible to the obligor, the party paying, and is includable as income to the obligee, the party receiving. Thus, spousal support dollars would have to be weighted heavier to achieve the resulting tax-affected $935 per month in this example. The trial court was clear at this time that it was using a software program called FinPlan to calculate the tax effects of these numbers. In fact, the trial court's record contains this actual calculation. If we assumed that the trial court's child support modification number of $665.50 were correct, then the resulting spousal support number would have to be increased to $1,008.33 per month, which is a combined number of approximately $1,673 per month to result in the same tax-affected number as the original $1,600. And the software would have actually done that. All the trial court did in this case was to re-income equalize, subsequent to the modification of child support based on the parties' revised incomes. This is in direct contravention of the parties' bargained for agreement that sets the limitation on the amount of future support modifications during the period spousal support was to be paid. It is well established in this court's case law, which was also cited by the trial court, that the intent of the parties must be followed. That's the Matheny case, Matheny. The ambiguity issue, Your Honors, also has to be considered, as the trial court found that there was no ambiguity, but went in a complete opposite direction of what I'm arguing here today. The trial court found that the parties unequivocally bargained that their incomes would be re-equalized upon a modification proceeding. If you think about that for a moment, there's nowhere in the divorce decree that the words income equalization appear. This was a guess by the trial court at the parties' intent, with the result of a conformity to the court's standard on how they modify support orders. If anything, Your Honors, the trial court's finding that the parties intended a re-income equalization is an alternate interpretation of the clause that I started my argument out with. We believe that while the trial court's interpretation is incorrect, if you take that interpretation as an alternate theory, Your Honors, then you have an ambiguity problem. This court has found that where terms of an agreement are ambiguous, the court may consider it extrinsic evidence to interpret or construe terms or to supply an omitted term. That's the Ryan case. And the Klein case cited in our brief indicates that parole evidence can come in from the parties to offer evidence as to their interpretation of what the clause meant, so that the court can make a proper interpretation. In closing, Your Honors, I do want to focus my attention briefly on the spousal support modification findings. And in particular, as the court is aware, the Casper case indicates that the trial court must, after finding it has jurisdiction to modify spousal support, the trial court must consider the ORC 3105.18 factors. And those factors for proof in terms of a modification of spousal support would have been the burden of the appellee in this case. This is not an income equalization case alone, Your Honors, and the record is devoid of evidence. The trial court's record is devoid of evidence to support an analysis of the 3105.18 factors, with the exception of the income of the parties. And lastly, Your Honors, I point your attention to the Supreme Court of Ohio in the Koch case, which discusses the appropriate and reasonable standard when dealing with spousal support modifications as well, finding that limiting the analysis to an increase in income was plain error, and other factors like living expenses have to be considered when deciding appropriate and reasonable in a spousal support modification. Thank you, Your Honors.
All right, Mr. Sherman, you have 3 minutes and 27 seconds for rebuttal.
Thank you.
Counsel, you have 15 minutes.
Thank you. Attorney Steve Bailey for the appellee. First of all, I want to address one of the statements counsel made, that this entire appeal rests upon interpretation of that language. While we do believe the interpretation was exactly correct, I don't agree with that statement, because in point of fact, there's no such thing as being a little bit pregnant, and there's no such thing as being a little bit reserved jurisdiction. They reserve jurisdiction over the issue of spousal support unequivocally and without limitation. And I cited this court to its decision in Latimer, which I think is extremely important. In Latimer, the gentleman had a 90-month spousal support obligation of $1,000, and he got an offer for an early buyout from Ford. And he had about, I don't remember exact numbers, but he had maybe 3 months of spousal support, maybe 4 to pay left. Her share of the early buyout money was more than the rest of the spousal support. It was more than 4 months, but it was her share of the buyout was more than the spousal support and the remaining spousal support. And so he filed a motion to terminate his spousal support upon taking the buyout. The court not only denied the modification, but sua sponte, without a motion, without being asked, without the case having, this issue even having been litigated before the magistrate, the court, upon objections, lifted the 90-month term and made it for life. But this court, I was on that case, and I was a little astounded by it, and it was a difficult conversation with the client, and I came to this court, and this court said, look, she reserved jurisdiction. That's she. I'm sorry, the trial court reserved jurisdiction. And so the trial court is not limited in the way in which it exercises sound discretion in modifying the support. Therefore, I think, in a sense, the entire argument of the interpretation of this sentence is fallacious in a way, because frankly, the court could do whatever it wanted to with spousal support, so long as it found that there was a significant change in circumstances. Now, to the language itself, I wrote a paragraph in my brief that illustrates how easy it would have been to do what the appellant is arguing was their intent. In the event that the child support in the future is modified, the spousal support shall be modified to create the same number, $1,600 per month. I've done it 1,000 times. That's not what they did. They used this term, net after tax effect. Well, we all got hung up on FinPlan, and I at the time when it first became new, I was kind of against it, but it became the thing, and we all started using it. And it shows us the net after tax effect of various support levels. And in this particular case, the net after tax effect of the support in the original decree was 50.1% of the available cash to dad, 49.9% to mom. What other meaning could net after tax effect be given? It is, to me, obvious, and the court's interpretation exactly correct. And I don't give a hootin', you know what, for this comma argument. I honestly, I said in the brief, I'll concede that the word same modifies the rest of that sentence. It doesn't matter. Everybody says, okay, here's what we're doing. We're going to give dad, we're going to essentially equalize income. It was, 0.1% off. And we want to keep that same net after-tax effect if we do a modification later. Why use those words? Why use those words? I think they absolutely had that meaning. And so I think the court's interpretation here was spot on. I don't necessarily support everything the court said and how it got there. I'm not sure I would have gotten there that way, but I think it got to the exact same place it should have. And certainly not an abuse of discretion. Now, I do want to address this last point that they make in their brief, because I think it's interesting, and I think it's important. Essentially, what they're arguing is that if the court doesn't explicitly say that it has considered the factors in 310518, then it has committed error. And I will represent to the court, we could find no case law support for that proposition. Obviously, there's myriad of case law that supports the proposition that the court has to consider those factors. But there's absolutely no case law that says it explicitly has to say that it considered those factors. And there's a presumption of correctness in a court's decision, as the court well knows. It reminds me, and I'm not a criminal lawyer anymore, but it kind of reminds me of these arguments about sentencing, or that I've seen that if the court doesn't actually articulate particular things, the case comes back for resentencing. If we want to go there, it's your privilege, obviously, to do that. But I think it's a dangerous precedent. There are 14 factors in 3105.18. The last, as I'm sure the court's well aware, is all other things the court deems relevant. We would put the courts in position of having to do a full-length analysis of all 14 factors, and many of which, not many, the vast majority of which don't apply in most cases. And I don't think that's, I do not believe that is where we would want to go. Obviously, it's your decision. We could also say, well, you don't have to cite every one of those factors, but you at least have to say that you considered them. But I think that flies in the face of you know, all of our experience in American jurisprudence, which presumes the correctness of courts' decisions and factual findings, because we know the court has to consider those factors. And I don't believe requiring a court to explicitly state that serves any real purpose. As I pointed out in my brief, the facts of this case do support the court's decision under those factors. I cited two specifically, including the catch-all at the end. I guess I have a little time. All I'll spend that doing is talking about change of circumstances. I would certainly agree that the term significant change of circumstances could use some illustration, could use some clarification, I guess I should say. But I don't think we can put a static percentage or dollar amount rule on that. In this particular case, there was two things. There was the loss of child support to my client, and there was an increase of $25,000 a year to the appellant. They argue that that wasn't a significant change of circumstances, citing it to other cases and other, but this is really a case-by-case determination. This one has to be a case-by-case determination. A $25,000 increase in income to a guy who originally was making $1.5 million might not be a significant change of circumstances. Whereas in the one case they cited, I'm sorry, I don't have that in my head, an increase in a person who was at poverty level to amount just over poverty level wasn't a significant change of circumstances. If there were a percentage at one point, I could be wrong, but I think in the lower court in the objection process, there was an argument about percentages, and that some court had found 20% was not a significant change of circumstances. I think if we put that kind of static rule in place, we are taking away the discretion of the court in a way that is really dangerous, because every case is very limited.
To that argument, the court in its order said the court finds the parties intended the net after-tax effect to mean income equalization.
Mm-hmm.
Do you agree with that statement?
Yes. No, well, I agree with the statement that it intended for the same net after-tax effect to be achieved, which was 50.1 and 49.9.
So it might have worked out in this case that to be essentially income equalization,
It is, yes.
but the statement is that first the court finds it unambiguous and then finds it to be intended to mean income equalization. So when you are talking about going from a pauper to just over, or going from, someone who is very, very wealthy,
Well, I think,
I don't know.
well, I think I illustrated in my brief that if the appellant's position were to be accepted, those numbers would have been 56-44. And I think in a case like this, with the income numbers we're talking about, 50.1 and 49.9 versus 56.44 is a significant change of circumstances.
So I'll read you the rest of the sentence, which I failed to read the first time, which the whole sentence is, the court finds the parties intended the net after-tax effect to mean income equalization, comma, after taking into consideration the tax consequences for both father and mother.
Same thing. Same thing. Yeah, absolutely. I mean, FinPlan has done something that I have personal feelings about that don't matter here, okay? But it has tried to place structure into a spousal support system that has never had structure. I mean, ever since I've been a lawyer, they've been struggling with trying to get a formula for spousal support, and they just can't do it. And so FinPlan came into that rather chaotic situation where you get, you know, $2,000 a month award here and 11 miles that way. In Wayne County, you get $200 a month. And said, well, okay, here's a tool for telling you what income equalization looks like. Now you guys can do what you want with that information. And some courts have said, in Summit County, you know, FinPlan is like, it was in the statute. Okay, and some courts have said, well, okay, this is income equalization, we're not going there, we're gonna, but it's still an important tool to show where income equalization stands. And in this particular case, all the court did was keep the same net after-tax effect, 50.1, 49. And I don't know what else it could have done, because why use the words net after-tax effect? Why not just say $1,600? Could have done that, should have done that if that's what they intended. But I suspect that the appellee's trial counsel would not have agreed to that language, because it's not what he intended.
And there's also some sort of presumption in this whole discourse, isn't there, that the phrase was entered on behalf of the to benefit the obligor and not the obligee.
I'm sorry.
We've only been examining it as it relates to the obligor in terms of tax effect,
Mm-hmm.
unless you get back to the income equalization.
Well, but I think that income equalization, if you call it that, because it was close enough, I think it's what they intended. I think it's what they intended. I mean, could they have said it more clearly? Absolutely. I do it all the time, and I make it very explicit. But that doesn't change the fact that the net tax effect has to be given that the words net tax effect has to be given some meaning here. Thank you.
Councilman, I was just going to say,
Oh, yes.
with everything you've argued and the other side, you keep on talking about what they intended. That sounds like ambiguity.
I don't think it's ambiguous, but I certainly understand that argument. And I think if there was an ambiguity, then the court's decision is still supported, because what the court then did was imply a term that it considered to be reasonable. And while the court found there to be, I said before, I'm not sure I would have got there the way the court got there, but I think where it got to was the right place. And if there wasn't an ambiguity, the court had to fill in a reasonable term, and it did exactly that. It filled in what it considered to be a reasonable term. So I don't think that changes things. And I just want to end with where I started, with Latimer. Because I do not believe that the court is confined to anything other than its own discretion when you completely reserve jurisdiction. If you want to limit the reservation of jurisdiction and make them a little bit pregnant, you can do that, but you have to say, court reserves jurisdiction only to the extent as stated herein. And we didn't do that in this case. Thank you.
Thank you. Counsel, you'll have 3 minutes, 27 seconds.
Thank you, Your Honor. Real quick with Latimer, what counsel is leaving out, the distinction between Latimer and this case is in Latimer it was completely open-ended. There was no explanation of what limitations there were, and there were no limitations on further jurisdiction. It just said the court has continuing jurisdiction, period. Whereas in this case, a close reading of the divorce decree, you will find it says any modification of either child or spousal support has to take into account this net after-tax effect. And to go all the way toward the end of Mr. Bailey's argument, he talks about formulas and static rules. Wouldn't a formula or static rule be income equalization to consider nothing else other than re-income equalizing the parties' incomes on a modification and considering no other factors? I know that Mr. Bailey's position is it's not really income equalization because it's 50.1, and that's a product of the software program. When you plug the numbers in, sometimes you can't quite get to 50.0 and 50.0, so you end up with 50.1 and 49.9. And I will agree with Mr. Bailey's interpretation of the grammar, and that the word same does modify the entire paragraph. And again, what Mr. Bailey failed to acknowledge is the same as what the trial court failed to acknowledge, is that end of that clause, which states the support orders as set forth herein, that was $800 a month in child support, $800 a month in spousal support. And there's a reason that it doesn't say $1,600. And the reason is you cannot fix a child support amount. The way when parties bargain to have a fixed amount of combined numbers like the 1,600, you have to set it up in a way where if one goes up or down, the other one has to also be modified. But in and of itself, child support cannot be fixed. Ohio case law indicates that parties cannot bargain the child's right to support away. So child support's always modifiable, so you have to leave it open that you may not end up with 800 and 800, but you could still end up with two different numbers than 1,600 that result in the same tax-affected number of the 1,600, that if one goes up and you apply the tax principles, that you can end up with the same net effect in the $1,600. I want to, real quick, the substantial change in circumstances, because I think it's substantial, not significant, is only one thing that the court has to look at in spousal modifications. And we keep talking about whether or not the income equalization in this case is a substantial change. I think that the court is flawed in its decision in not also considering the appropriateness and reasonableness and the 3105-18 factors, because it is not a static rule as Mr. Bailey indicated. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail a copy of that decision to each of you on the day it's released, and the opinions are posted on the Supreme Court of Ohio's website.